Greetings, creators. Welcome back. Today we're continuing Encyclopedia Britannica's Bank and Banking. The Panic of 1907 imposed a severe strain upon the cash resources of the banks of New York City, but did not cause any such considerable number of failures as occurred in 1893. Payment of checks in currency was suspended in New York on the 28th of October 1907 and continued until about the beginning of the year 1908. The panic was precipitated by over-speculation by a group of national banks, followed by the suspension of the Knickerbocker Trust Company on the 22nd of October with deposits of 48 million. Then came runs on other companies, a deficit in the required reserves of New York banks of 38,800,000 in the week of 2nd November, and arrangements for the importation of foreign gold to an amount which soon approached 100 million. With an increase during the autumn of about 77 million in national bank circulation, a transfer of 72 million from the Treasury to the banks, and a further decline in required reserves in New York during the next week, the amount of currency which was added to the circulation or disappeared during a few weeks of the panic amounted to more than 275 million, or nearly 1/10 of the usual volume of circulation in the country. The total banknote circulation on the 28th of December 1907 had risen to 687 million. But this amount was abnormal and was reduced somewhat during the spring of 1908. The position of the trust companies, especially those the city of New York, the position of the trust companies, especially those of the city of New York, was one of the disturbing features of the panic. These companies were comparatively a small factor in New York finance at the time of the panic in 1893. The capitalization of all the trust companies in the United States, even as late as 1897, was only 106,968,253, and individual deposits were 566 million. The capital of these companies had risen in 1907 to 276 million, and their deposits to 2 billion. The trust companies of New York were required by the law of the state to maintain only 5% of their demand deposits in cash in their vaults. Whilst most of them had also large amounts of deposit in national banks, these reserves proved inadequate to sustain the vast mass of credit which was built upon them. The absolute amount of the reserves, however, was perhaps less important than the class of business to which some of the less conservative of these companies had committed themselves. Instead of keeping their assets liquid by purchases of commercial paper and loans on first-class negotiable securities, they had in some cases engaged in speculative underwritings and had locked up their funds in enterprises requiring a long time for their consummation. It was these combined influences which led to distrust of the Knickerbocker Trust Company, and to the runs upon that company and others during the late days of October and early November. The result was to reduce the total resources of the 48 trust companies of Greater New York from 1,205,019,700 on the 22nd of August 1907 to 858,674,000 on the 19th of December 1907. Individual deposits subject to check fell from 692 million to 437 million. Such a reduction of resources within so short a time, most of it being accomplished within a few weeks, has hardly ever been recorded in the history of banking. And the fact that the stronger companies were able to call in their cash and meet such demands was evidence to a certain extent that the criticisms upon them were exaggerated. The necessity for stronger reserves and for greater safeguards against speculative operations was so strongly impressed upon the public mind, however, that several restrictive measures were enacted at the session of the New York legislature in 1908, designed to prevent any abuses of this sort in the future. The function of issuing notes, which is exclusively a privilege of national banks, has diminished in importance in America, as other methods of transferring credit have attained a wide development. This has not only been true of the national banks themselves, but has accounted for the development alongside the national banking system of state banks, private banks, and trust companies, which have not had the privilege of note issue, but have obtained other privileges sometimes greater than those of the national banks. The aggregate resources of all classes of banks in the United States have greatly increased in recent years. The following table shows the increase in the chief items of the accounts of national banks for representative years from the reports made nearest to the beginning of the year. And there's a table here, progress of national banks from 1865 to 1908. You have the year, then you have the number of banks, you have the loans and discounts for the years, and then you have the individual deposits for the years. The combined returns of state and private banks, savings banks, and loan and trust companies in the United States show a growth within a few years, which is indicated by the principal items of their accounts. And then you have another table, you have resources of state banks, trust companies, etc. You have items, you have the year in 1897 to 1907, and then you have the list of items. So they do capital stocks, they do surplus and profits, they do loan deposits, and do the total resources. All these, this is the amount here, the total resources, right? So the aggregate banking power of the United States, as computed by the Comptroller of the Currency in his annual report for 1907, increased from 5,150,000,000 in 1890 to 17,824,800,000 in 1907. And the banking power of foreign countries from 10,835,000,000 to 27,034,200,000, representing an increase for all reporting countries from 15,985,000,000 to 44,859,000,000. The system of clearing checks has attained a higher development in the United States than in any other country except perhaps Great Britain. Clearing houses exist in about 112 leading cities, and the aggregate clearings for the year ending 30th September 1907 reached 154,662,515,258. The New York Clearing House inevitably does a large proportion of this business. Its clearance constituted in 1906 67.2% of the total clearings in 55 of the larger cities. The volume of clearance fluctuates greatly with the volume of stock exchange transactions and with the business prosperity of the country. An indication of these fluctuations at New York is afforded by the following table taken from Conant's Principles of Money and Banking brought down to 1907. The Clearinghouse Committee of the New York Clearinghouse exercises a powerful influence over the banking situation through its ability to refuse aid in emergencies to a bank which is unwisely conducted. This power was used in the Panic of 1907 to eliminate several important but speculative financial interests from control of national banks. Only national and state banks and the sub-treasury were members of the clearinghouse at this time. And now this is a table here, variations in clearing at New York from the year 1870 to 1906. Average daily clearance. This is the amount of funds that transact on a daily basis. Percent balances to clearance. This is the percent. And then the remarks. So you have great business activities, industrial depression, so it's showing the year and the remarks for that year. Right? And what took place. Their weekly reports of condition were awaited every Saturday as an index of the state of the money market and the exchanges. But this index was incomplete and sometimes misleading because regular weekly reports were not made by trust companies. It was announced early in 1908 by the state superintendent of banking that he would exercise a power vested in him by law to require weekly reports in future from trust companies, so that the two classes of reports would present a substantially complete mirror of banking conditions in New York. And that article, the authorities for that article was taken from these sources here. All right, William M. Gog, History of Paper Money, Banking in the United States, Philadelphia, 1833, all the way down to the Second Bank of the United States of Chicago, 1903. All right. So they say much statistical information is contained in the annual reports of the Comptroller of the Currency of the United States published annually at Washington. Now we move on to English law affecting banks and their customers. Issue of notes. Remember, a note is a promise, a promissory note. It's a promise to pay, which means it's just a representative of specie of gold and silver or of substance. All right. The legislation which culminated in the Bank Charters Acts of 1844 and 1845 secured to the Bank of England the absolute monopoly of the note issue within the City of London and a 3-mile radius. Outside that radius and within 65 miles of the city, there is a concurrent right in banks consisting of 6 or less than 6 persons established before 1844 and issuing notes at that date beyond the 65-mile radius. The privilege may be exercised by all banks established before 1844 and then issuing notes who have not since lost their right to do so by bankruptcy, abandonment of business, or temporary suspension of issue. According to some authorities, the effect of the 20 and 21 Victoria, Cap 49, Section 12, re-enacted Companies Consolidation Act 1908, Section 286, subsection D, was to sanction the increase in the constitution of any bank issuing notes outside the 3-mile and within the 65-mile radius from 6 to 10 persons without affecting the power to issue notes. The rule as formulated above is, however, that enunciated by Bowen J. in Capital and Counties Bank versus Bank of England 1889, 61 LT 516. The increase in the number of joint stock banks and the gradual abortion of the smaller and older concerns have had the effect of minimizing the output of notes other than those issued by the Bank of England, as exemplified by the case of the Attorney General versus Birkbeck 12 QBD 57. It would seem impossible to devise any scheme by which the note issuing power of an absorbed bank could be continued to the new or amalgamated body. But a bank having the right would not necessarily lose it by absorbing other banks. Capital and Counties Bank versus Bank of England. Foreign banks may establish branches in Great Britain on complying with the regulations imposed on them by the Companies Consolidation Act of 1908, but cannot apparently issue notes even though payable abroad. So now we go on to deposit business. The term bank deposit gives a mistaken idea of the real relation between banker and customer. All right, so we go down here to relation between banker and customer. So long ago as 1848, it was decided by the House of Lords in Foley versus Hill, 2H of L 28, that the real relationship between banker and customer was that of debtor and creditor, not in any sense that of trustee and seteki trust, or depositee and depositor, as had been formerly supposed and contended. The ordinary process by which a man pays money into his account at his banker's is in law simply lending the money to the banker. It fixes the banker with no fiduciary relation, and he is in no way responsible to the customer for the use he may make of the money so paid in. And, as being a mere debt, a customer's right to recover money paid in is barred on the expiration of 6 years by the statute of limitations if there has been no payment meantime on account of principal or interest and no acknowledgement sufficient to bar the statute. This was in Pott versus Clegg, 16M and W 321. Such a state of affairs, however, is hardly likely to arise inasmuch as, in the absence of specific appropriation, earlier drawings out are attributed to the earlier payments in, as in the ordinary case of current accounts, and so the items on the credit and debit side cancel each other. An apparent exception to this system of appropriation exists in cases where a man wrongfully pays into his own account monies held by him in a fiduciary capacity. In such circumstances, he is presumed to have drawn out his own monies rather than those affected by the trust, and so long as the account is in credit, any balance will be attributed to the trust money. As between contending claims to the money based on different breaches of trust, the ordinary rule of appropriation will apply. It has often been suggested that the only method of withdrawing money from a banker is by check, that the presentation of a check is a condition precedent to the liability of the banker to repay, and this section is checks. This is not so, such a view being inconsistent with the cases establishing the effect of the statute of limitations on money left in a banker's hands, and with the numerous cases in which a balance at a bank has been attached as a simple and unconditional debt by a garnishee order, as for instance in Rogers versus versus Whiteley 1892 AC 118. The banker's position with regard to checks is that superadded to the relation of debtor and creditor, there is an obligation to honor the customer's checks, provided the banker has a sufficient and available balance in his hands for the purpose. Foley versus Hill. If having such funds in his hands, the banker dishonors a check, he is liable to the customer in substantial damages without proof of actual injury having accrued. Rowland versus Stewart, 14 CB 595. And what we can do, we can shepherdize these cases and see if they are still good law today, meaning that they weren't overturned by other case law. So if they are still good law after shepardizing, these are case laws that can be cited to give effect to a fact that we are bringing before the court. All right? Where several checks are presented simultaneously and the available balance is insufficient to pay all, the banker should pay as many as the funds will cover and is not bound to discriminate between particular checks. It would seem a legitimate condition that a check should be drawn in the ordinary recognized form, not in one raising any question or doubt as to its validity or effect. Checks drawn to wages or order, petty cash or the like are common and are sometimes regarded as payable to bearer. Such payees are not, however, fictitious or non-existent persons, so as to render the checks payable to the bearer under Section 7, subsection 3 of the Bills of Exchange Act 1882, nor can such payees endorse. Some banks refuse to pay such checks, and it is conceived they are justified in so doing. Money paid in so shortly before the presentation of the check that there would not have been time to pass it through the books of the bank would not be treated as available for drawing against. If a person have an account at one branch of a bank, he is not entitled to draw checks on another branch where he has either no account or is overdrawn. But the bank has, as against the customer, the right to combine accounts at different branches and treat them as one account. Garnett versus E.O.N. LR 8 EX 10. Funds are not available so long as a garnishee order founded on a judgment against the customer is pending, since it attaches all monies on current account irrespective of the amount of the judgment. Rogers versus Whitley. The very questionable practice of post-dating checks has been the source of considerable doubt and inconvenience to bankers. The use of such documents enables the drawer to obtain the results of a bill at a fixed future date without the expense of a regular bill stamp. But the Bills of Exchange Act 1882, Section 13, subsection 1, provides that, quote, a bill is not invalid by reason only that it is antedated or post-dated or that it bears date on a Sunday, end quote. The banker cannot therefore refuse to pay a check presented after the apparent date of its issue on the ground that he knows it to have been post-dated. On the other hand, he is entitled and indeed bound to refuse payment if such a check is presented before the apparent date of its issue. This was in a court case, Morley versus Culverwell, 7 M&W at P178. Revocation of authority to pay a check must come to the banker's conscious knowledge and be unequivocal both in terms and method of communication. He is not bound to act on an unconfirmed telegram, Curtis versus London City and Midland Bank 1908, 1 KB 293. The banker's authority to pay checks is terminated by the death, insanity, or bankruptcy of the customer or by notice of an available act of bankruptcy committed by him. The banker is bound to observe secrecy with respect to the customer's account unless good cause exists for disclosure, and the obligation does not cease if the account becomes overdrawn. Hardy versus VC, LR 3EX 107. In England, a check is not an assignment of funds in the banker's hands. Bills of Exchange Act 1882, Section 53. The holder of the check has therefore no claim on the banker in the event of payment being refused, his remedy being against the drawer and endorser, if any. On this section is also based the custom of English bankers not to pay part of the amount of a check where there are funds, though not sufficient to meet the whole amount. The section does not apply to Scotland, where it would seem that the bank is bound to pay over what funds it has towards satisfaction of the check. A banker is entitled to hold paid checks as vouchers until there has been a settlement of account between him and the customer. The entries in a passbook constitute prima facie evidence against the banker, and when returned by the customer without comment, against him. But the proposition that such return constitutes a settlement of account has been much disputed. Indeed, where forgery is the ground of a repudiation of a check, no dealings or omissions of the customer with regard to the passbook would seem to preclude him from objecting to being debited and throwing the loss on the banker. This coming out of a court case, Kipiligala Rubber Company versus National Bank of India, 25 times LR 402. As against the banker, however, credit entries in the passbook cannot be disputed if the customer has altered his position in reliance thereon, and checks drawn against an apparent balance must be honored. Holland versus Manchester and Liverpool District Bank, 25 times LR 386. The rule by which the holder of a check has no direct recourse against the banker who dishonors it holds good even where the banker has before issue marked the check as good for the amount, such marking not amounting to an acceptance by the banker. As between banker and banker, however, such marking or certifying probably amounts to a binding representation that a check will be paid, and if done by request of the drawer, the latter cannot subsequently revoke the authority to pay. In certain circumstances, marking at the instance of the person presenting the check for payment may amount to an undertaking by the banker to hold the money for his benefit. In Re Beaumont, 1902, 1 CHP 895. A banker either paying or collecting money on a check to which the person tendering it for payment or collection has no title or a defective title is prima facie liable to the true owner for conversion or money had and received, notwithstanding he acted in perfect good faith and derived no benefit from the operation. Payment of an open check payable to bearer either originally or by endorsement is, however, in all cases a good payment and discharged. Charles versus Blackwell, 2 CPD at P158. Limited protection in other cases has been extended by legislation to the banker with regard to both payment and collection of checks, usually on the principle of balancing some particular risk imposed on him by enactments primarily designed to safeguard the public. By Section 19 of the Stamp Act 1853, the banker paying a draft or order payable to order on demand drawn upon him was relieved from liability in the event of the endorsement having been forged or unauthorized. This enactment was not repealed by the Bills of Exchange Act 1882 and in London City and Midland Bank v. Gordon 1903 AC 240 was held to cover the case of drafts drawn by a branch of a bank on its head office. Section 60 of the Bills of Exchange Act 1882 extends like protection to the banker in the case of checks, the definition of which therein as, quote, so bills drawn on a banker payable on demand, end quote, debars drafts of the above mentioned description. Such definition involving the unconditional character of the instrument also precludes from the protection of this section the documents now frequently issued by corporations and others which direct bankers to make payments on a specific attached receipt being duly signed. London City and Midland Bank v. Gordon. Section 17 of the Revenue Act 1883. However, applies to these documents the cross-check sections of the Bills of Exchange Act 1882. See Bavias Jr. and Sims v. London and Southwestern Bank 1900. 1 QB 270. While denying them the position of negotiable instruments, and a banker paying one of them crossed in accordance with the crossing, and in the absence of any indication of its having been transferred, could probably claim immunity under Section 80. The Bills of Exchange Act 1882 contains no direct prohibition against a banker paying a cross check otherwise than in accordance with the crossing. But if he do so, he is liable to the true owner for any loss suffered by him in consequence of such payment, Section 79, and is probably unable to charge his customer with the amount. A banker paying a cross check in accordance with its ostensible tenor obtains protection under Section 80 and the proviso to Section 79. Questions have arisen as to the bearing of the crossed checks sections when a crossed check drawn on one branch of a bank is paid in for collection by a customer at another branch, but the transaction is so obviously a legitimate and necessary one that either by the collecting branch may be regarded as a separate bank for this purpose, or Section 79 may be ignored as inapplicable. Gordon v. London City and Midland Bank 1902, 1 KB 242 CA. The collection of cross checks for a customer being virtually incumbent on a banker, qualified immunity is accorded him in so doing by Section 82, a final exposition of which was given by the House of Lords in London City and Midland Bank v. Gordon 1903, AC 240. To come within its provisions, the banker must fulfill the following conditions. He must receive the check from and the money for a customer, i.e. a person with whom he has definite and existing business relations. See Great Western Rye Company v. London and Company Bank 1901 AC 414. So this is a beautiful quote here. So to come with its provision, the banker must fulfill the following conditions. He must receive the check from and the money for a customer. That is, a person with whom he has definite and existing business relations. Right? See Great Western Rye Company versus London and County Bank 1901 AC 414. He must take the check already crossed, generally or specially to himself. His own crossing under Section 77 is absolutely inefficacious in this connection. He must take the check and receive the money in good faith and without negligence. Negligence in this relation is the omission to exercise due care in the interest of the true owner, not necessarily the customer. To avoid this disqualification of negligence, the banker must see that the endorsements, where necessary, are ostensibly correct. He must satisfy himself of the authority where an endorsement is per procuration. He must not take for private account a check which on its face indicates that the holder is in possession of it as agent or in an official capacity or for partnership purposes. Hannah's Lakeview Central Limited versus Armstrong and Company, 16 times LR 236, and Bevan versus National Bank, 23 times LR 65. He must not take a check marked account payee for an account other than that indicated. This is in Bevan versus National Bank. It is further demonstrated by the Gordon case that the banker only secures protection so long as he is acting strictly as a conduit pipe or as agent for the customer. If he put himself in the position of owner of the check, he no longer fulfills the condition of receiving the money only for the customer. In the Gordon case, adoption of the not uncommon practice of crediting checks as cash in the bank's books before the money was actually received was held equivalent to taking them as transferee or owner and to debar the bank from the protection of Section 82. The anxiety and inconvenience caused to bankers by this unexpected decision was ultimately removed by the Bills of Exchange Cross Checks Act 1906, which enacts that a banker receives payment of a cross check for a customer within the meaning of Section 82 of the Bills of Exchange Act 1882, notwithstanding that he credits his customer's account with the amount of the check before receiving payment thereof. See this word credit? I want you guys to go and do an in-depth research on this word credit. Apparently, the scope of this act must be confined to its immediate object, and it does not affect the relations and rights between the banker and his customer or parties to the check arising from such crediting as cash. For instance, the customer, in the absence of agreement to the contrary, may at once draw against checks so credited, while the banker may still debit the customer with the amount of the check if returned unpaid, or sue the drawer or endorser thereon. The protection to the collecting banker is in no way affected by the check being crossed, not negotiable, or by the nature of the fraud or crime by which the check was obtained by the customer or any previous possessor, although there are dicta which have been interpreted in the contrary sense. Nor does the fact that the customer is overdrawn deprive the banker of the character of a collecting agent, unless the check be definitely given and taken in reduction of such overdraft. Where the conditions requisite for protection exist, the protection covers not only the receipt of the money, but all operations usual in business and leading up to such receipt, on the basis of the customer's title being unimpeachable. The provisions of the cross-check sections of the Bills of Exchange Act 1882 are extended to dividend warrants by Section 95 of that Act, and to certain orders for payment issued by a customer of a banker by Section 17 of the Revenue Act 1883, as before stated. But the wording of the Bills of Exchange Cross-Checks Act 1906, specifying as it does checks alone, appears to extend documents of both these classes from its operation. With regard to orders for payment, inasmuch as the same section which brings them within the cross-check sections expressly provides that they shall not be negotiable, a banker would probably be protected only in taking them from the specified payee, though this distinction has been ignored in some recently decided cases. A check is an order, though. A check is an order. So I don't know why they're stating that this cross checks act exclude documents of both these classes from its operation. A check is an order. With regard to the orders for payment, in as much as the same section which brings them within the cross check sections, orders for payment, a check is an order. Okay. So we go down to fraud. So where a banker incurs loss through forgery or fraud in circumstances not covered by statutory protection, his right to relief, if any, must depend on general principles. He cannot charge his customer with payments made on a forgery of that customer's signature on the ground either that he is presumed to know such signature or that the payment is unauthorized. But if the customer has accredited the forgery or having knowledge or reasonable ground for belief that it has been committed, has failed to warn the banker, who has thereby suffered loss or prejudice, the customer will be held estopped from disputing the banker's right to debit him with the amount. And this is a case Vagliano versus Bank of England, 1891 AC 107, Mackenzie versus British Linen Company, 6 AC 82, and Ewing versus Dominion Bank, 1904 AC 806. The doctrine of the fictitious person as payee may also exonerate a banker who has paid an order bill to a wrongful possessor. Payment on a forgery to an innocent holder is payment under mistake of fact. But the ordinary right of the payer to recover money so paid is subordinated to the necessity of safeguarding the characteristics of negotiability. Views differ as to whether the recovery is precluded only where the opportunity of giving notice of dishonor is lost or prejudiced by delay in reclaiming payment, or whether mere possibility of damage is sufficient. This is London and River Plate Bank versus Bank of Liverpool, 1896, 1 QB 7, and Imperial Bank of Canada versus Bank of Hamilton, 1903 AC 49. Cases have frequently arisen where the carelessness of a customer in filling up checks has enabled a person to fraudulently increase the sum for which such checks were originally drawn. In Colonial Bank of Australasia or Australasia versus Marshall, 1906 AC 559, the Judicial Committee of the Privy Council held that the affording such facilities for forgery was no breach of the customer's duty to his banker, and that the latter was not entitled to debit the customer with more than the original amount. As before stated, the customer's dealings with the passbook cannot, in the present state of the authorities, be relied on as debarring him from disputing unauthorized payments appearing therein. All right. Custody of valuables. Let's see. Custody of valuables. All right. We're going to continue here. Custody of valuables. The payment of bills accepted payable at the bank is not like the payment of checks, an essential obligation of the banker, and the risk involved is enhanced by the fact that the banker must pay or refuse payment at once, no interval being allowed for verification of endorsements. The abolition or modification of the practice has frequently been advocated, but it is one of the facilities which competition compels bankers to extend to their customers. On the same basis stands the receipt of a customer's valuables for safe custody. The question of the banker's responsibility for the loss of goods so deposited with him was raised, but not decided in an action brought by Mrs. Langtry against the Union Bank of London in 1896. Certain jewels belonging to her had been delivered up by the bank to an unauthorized person on a forged order. The case was settled, but bankers being desirous to ascertain their real position, many legal opinions were taken on the point, and after consideration of these, the Central Association of Bankers issued a memorandum in which they stated that the best legal opinion appeared to be that a distinction must be drawn between cases in which valuables were by mistaken delivered to the wrong person and cases in which they were destroyed, lost, stolen, or fraudulently abstracted, whether by an officer of the bank or some other person. So that in the former case, the question of negligence did not arise. The case being one of wrongful conversion of the goods by a voluntary act for which the bank was liable apart from any question of negligence. That in the second case, that of loss or theft, the banker being a gratuitous bailee would only be liable if he had failed to use such care as ordinary prudent man would take of valuables of his own. The latter rule is practically that laid down in Giblin versus McMullen LR 2 PC 318. But in estimating the amount of care to be taken by the banker, the nature of the goods, if known or suspected, and the exceptional means of protection at the disposition of bankers, such as strong rooms, must be taken into consideration. Methods of obviating both classes of risk by means of special receipts have frequently been suggested, but such receipts do not appear to have come into general use. So that was some nice information there. So let's see. So we're gonna stop here. All right, we're gonna stop here. All right. So I want to thank you guys for your time and patience. Remember, strength in body, powers in mind. Keep reading, keep studying, keep looking at the definition of the words. Follow my channel. I have other videos with trust terms, fundamentals. We're also doing a read on the Caribbean Commonwealth Trust by Codaline and Carmichael. All right. Check out those videos in collaboration with these videos for a much broader comprehension and understanding of the topics that are being covered. All right. So you guys be safe. Remember, we are all creators. Stay up.